Okay, good morning. Here I am this morning with Brandon Silver. Good morning, Brandon.
Morning, Julie. How are you?
I'm good, thank you. And we will be doing another one of Brandon's construction question times, where he answers some of the most frequently asked questions that we get in construction. So this morning's question, Brandon, is what is a disruption claim and how can such a claim be successful?
Yeah, so this is a regular question that we get, and often this is coupled with a question of what is a claim for delay, and usually there's some confusion between the two. So today I'm going to talk about a claim for disruption, how to bring a claim, such a claim can be successful. So firstly, I think it's important to actually explain what a claim for disruption is. And the most useful definition of disruption is actually from a passage from the Society of Construction Laws Delay and Disruption Protocol. So I'm just going to read you out now what the actual definition is of disruption. So disruption is a disturbance, hindrance, or interruption to a contractor's normal working methods, resulting in lower efficiency. Disruption claims relate to loss of productivity in the execution of particular activities. Because of the disruption, these work activities are not able to be carried out as efficiently, as reasonably planned, or as possible. So that's the definition as provided by the SCL protocol. So what you can see is at the core of a disruption claim are the additional costs incurred by the contractor as a result of not being able to work as efficiently as planned due to a disruption caused by the employer. Now, what follows from this is, well, what kind of events cause disruption? So this would be, for example, design changes instructed by the contractor, variations instructed by the contractor, the late issue of information or materials by the employer, or, for example, any other delay by someone else not being the contractor. So these are all kind of the events that would lead to disruption. Now, I mentioned at the beginning of this that one of the things that normally occurs is that people get confused between a claim for disruption and a claim for delay. So I think it's important to now explain the distinction between the two. And there's a really useful passage, which I'm just going to read, which really helpfully summarizes the distinction. So the passage reads as follows. The distinction between delay and disruption is important, but rarely articulated and is to an extent a matter of definition. Delay is usually mean to mean a delay to the completion date, which presupposes that the activity which was delayed was on the critical path. Disruption to progress, however, may or may not cause a delay to overall completion, depending on whether the activity delayed is on the critical path as explained above, but will result in additional cost where labour or plant is underutilised as a consequence of the event. So with delay, so summarising what this passage is, with delay, what happens is that you normally seek an extension of time because there's been an actual delay to the completion date. And that the reason for that is that the delay has been a delay to a critical event, which therefore has a knock-on effect on the completion date. With disruption, it may not, however, be affecting a critical activity, and therefore it may not actually require an extension of time, but because there is a disruption, they haven't been able to work as efficiently, and therefore additional costs have been incurred, and therefore your claim for disruption would be a claim for a loss and expense. So hopefully that just gives a brief summary of what actually a disruption claim is. So what follows from this is, well, what do you actually need to establish to have a successful claim for disruption? Now, the precedent case for this is Walter Lilly versus McKay. And what this case set out was three elements that have to be satisfied, that you have to prove on the balance of probabilities for your claim to be successful. So I'm just going to break up the three elements now and then briefly discuss each. So the first element is that the events occurred. You need to show that there's been events occurred which entitle it, i.e. the contractor, to loss and expense. Now, when I refer to the word events, obviously I just gave a few examples previously of the events that could cause loss and expense. Now, these events need to be relevant events, so they need to fall within one of the provisions within the contract. The contract will define what a relevant event is, and they'll give maybe, 10, however many different examples, and it needs to fall within one of those. So you need to satisfy that first element. The second element, of course, is that you need to show that those events have caused disruption and or delay. So pretty self-explanatory. And then thirdly, that the disruption caused loss and or expense to be incurred. So you need to actually show that additional costs have been incurred and that that's caused as a result of the disruption and not by something else. So those are the three elements. Now, I just like to stress that there is this kind of first hurdle that you actually need to satisfy before going into these three tests. And this is in relation to complying with notification provisions in the contract. So in a contract, what they will require is that the contractor notifies the employer as early on as possible that there is this event, that this event is causing disruption and that there's likely to incur loss and expense. So it's very important to notify this at the beginning. And indeed, in one case called the Van Erd case, they had a claim for disruption and they failed at the first hurdle because they did not comply with the contractual notification provisions. So this just stresses how important that it is, because otherwise your claim will fail at the first hurdle. So notification provisions is very, very important. So finally, before I conclude, as with all claims for disruption, claims for delay, whatever it is, it's very important to, of course, have evidence to substantiate your claim, to show, in this case, that there are events that have occurred that have caused disruption. So the question that follows is, well, what documents can I provide in support of my claim? And this normally is emails and letters between the parties, minutes of meetings, progress reports, site diaries, allocation sheets, site photos, personal notebooks. All of these things would be very useful. And indeed as well, the actual notification that you've given to the employer, as well as it being important because you have to comply with the actual contractual provisions. That shows evidence that you've realised it early on, and that would certainly help your case. So that's what a claim for disruption is. And hopefully you've also I briefly touched upon a claim for delay. So if you have any questions on that, how to make a claim, what you need to establish, then please don't hesitate to contact me. My email address is brandonsilver@silverllp.com. Thank you for listening.
No problem. Thanks, Brandon. That was enlightening as always, and we look forward to the next one next week. So
Thanks, Julie. Take care.
Have a great day.
You too. Bye.